Hi guys, it's Kathy. I hope you're doing well. And I hope you're not screaming at any judges today. Because when you scream at judges, bad things happen. I have a new judge for you, in a new state for you. North Dakota. I think I played him like once before on my channel a bit ago, but we rarely ever see anything from North Dakota. So I got a new judge, new state, who gets screamed at repeatedly from the inmate. I don't know if he's an inmate or just defendant. We'll just say defendant. And this judge, Patience of Job, he's like steady as a rock, like a robot even. I hope you enjoy it. Here we go.
State of North Dakota versus Jesse Hildebrandt, 02-2024 CR 144. Ms. Duffy appears on behalf of the state.
There he is.
Mr. Hildebrandt appears personally and with Mr. Barkus, his attorney. I want to make sure I understand the procedural posture here. Mr. Hildebrandt, you're currently at the state hospital, is that right?
No, I have not gone to the state hospital yet. I'm here to contest the fitness to proceed findings.
All right, so I want to stop. I want to make sure I understand. So procedurally, you were charged with the crime in June of 2024. There was a criminal information that was filed as Record Index 1. The court issued a warrant as Record Index 8. You were arrested on that warrant and it was served on July 10, 2024, Record Index 9. You had an initial appearance.
He's like a robot, but don't worry, Jesse's not.
Mr. Barkus was appointed as your court-appointed attorney. There was a motion for a fitness to proceed evaluation that was filed in September of 2024. Judge Schmitz signed that order requiring you to get an evaluation in September of 2024 as Record Index 25. On November 12, 2024, the state hospital filed a report concerning your fitness to proceed as Record Index 29. The court reviewed that fitness to proceed report and takes judicial notice of that report.
Guess what it said? He's not competent to proceed.
10 days later, no, not quite 10 days later, about a week later on November 19, 2024, Mr. Hildebrandt, you filed a letter with the court contesting some of the findings as Record Index 31. A few days later, on November 22, 2024, Ms. Duffy and your attorney entered a stipulation to suspend proceedings and commit you to the state hospital for competency restoration treatment. That was Record Index 32. On the same date, there was an order for restoration treatment, suspending the proceedings and committing you to the state hospital for treatment. That was Record Index 35. Just to make sure we're on board here, you were committed to the state hospital for a period of up to 180 days. On that date, November 22, 2024. And then there was an order for transport that Judge Schmitz signed as Record Index 39, filed on December 9, 2024. to transport you from the state hospital to today's hearing. And so what it looks like to me is that Judge Schmitz ordered you to go to the state hospital and to start treatment back in November of 2020, November 22, 2024. And he thought you were there. And you're telling me now that you haven't gone there?
No, I filed a motion a week and a half ago to contest these findings based upon what I have to present today is basically an oral argument to contest this fitness to proceed here.
So hold on. I want to make sure procedurally we're in line here.
Just
Okay.
one correction to that. The order for transport was an order not to come here today in order to transport him to Jamestown. So vice versa.
Gotcha.
So
Okay.
that I think affects your procedure.
Thank you. I was under the impression that he was there and was being transported back.
No,
There probably wasn't a bed available. That's what I'm guessing, because it takes a while for a bed to pop up.
and the reason for the delay in that is once we have that suspension order, the state hospital, in my previous practice, I've learned they don't allow people to just show up immediately. We have to schedule that with them. And so the delay in there was in an effort between myself and Mr. Barkas to line up a time. Subsequently, we couldn't do that. And then we had filed, the state had filed in order for transport.
Well, it's not what the statute says, but okay. All right. So, a couple of issues here. The first is whether or not those findings are contestable at this point. So, as the parties know, and Mr. Hildebrandt, I don't know if you know, the way that this process works is when there is objective evidence to cause the court concern that a person might not be fit to proceed, the court is required to hold a competency hearing if the findings are contested. And before we get to the competency hearing, there usually is a competency evaluation. In this case, there was a competency motion that was filed. The court granted the order. There was an evaluation. The evaluation findings came back, finding you lacking a fitness to proceed for not one, but two distinct and separate reasons. Based on that
There has to
report,
be more.
the parties agreed to the findings. And so the statute, North Dakota Century Code Section 12.10407, requires the court to hold a hearing only if the parties contest the findings. Here, the parties did not contest the findings. They stipulated to them, and a stipulation means that there was an agreement to the findings.
I did not agree to the findings.
I understand that you did not, but your attorney did. And when that happened, the court entered an order, and that order found you unfit to proceed. And so at that point, everything gets put on hold unless and until one of two things happens. The first thing that could happen is that you could be restored to competency. So there's already been a finding that you are not fit to proceed. The state bears the burden to prove you fit to proceed. And so at some point, if a Tier 1A mental health professional determines that you are fit to proceed, the court can hold a hearing to determine whether or not you are fit. Sometimes the attorneys agree that you're fit and have been restored to fitness. And then there is no hearing. There's just a motion and an order, or a stipulation and an order saying the prosecution can start the process again. So unpause. So that happens under one circumstance. There's a fitness finding because either a Tier 1A mental health professional determines you are fit, or the parties agree that you're fit. That does not happen in your case. Option two, the order suspending the proceedings allows that pause button to be pressed for a total of up to 180 days. If it looks like you're not likely to regain fitness within those 180 days, the court can have a hearing to determine whether or not to dismiss the charges against you, or the state can ask for an extension of time of that 180 days for another 365 days if there's medical evidence showing that there is a substantial likelihood that in that additional 365 days, you will be treated to competency. All right? And so here, we're not at that point yet because you haven't even started the treatment. And we're not approaching the end of the 180 days yet. And so that has not yet happened. So the first question is, right now, there's an order putting everything on hold. It's not procedurally the time to contest the findings because right now, the findings, you had an opportunity to contest them, you chose not to.
I actually did contest them, but the order was placed anyways, and it wasn't a complete contestation actually. And this notice right here claims that this hearing, this very hearing right now, was a hearing for a motion for self-representation and a competency evaluation. And that was scheduled for December 17th at 1 p.m. So that is the reason why I thought that I was here today.
Getting rid of his lawyer. That's a good sign of competency.
Was because of the motion that I presented last week. And that motion clearly shows my competency, and I feel like it's being unfairly weaponized against me because of very specific circumstantial pieces of evidence or circumstantial pieces of information that there are several pieces that are not being considered right now when it comes to that fitness evaluation. And in order for me to have the ability to, contest those findings, I need to be able to explain why that was a procedural error. Because I find the motions that were presented for the fitness evaluation by my lawyer to have been improper, because essentially what they had done, they relied on my protected communications with my attorney in order to find, reason to go and submit these motions. And so by my attorney using these as, evidence for an incompetency, it is unfairly prejudiced against my case because I have not exampled any incompetence whatsoever in my thus far. There's been no example of incompetence. It was filed based off of the disclosure I had made about my mental health disorder, which is a key mitigating factor when it comes to the actual charges that I'm facing right now. That mental health disorder,
my mental health disorder does not make me incompetent.
Taken the reflective capacity to, analyze my case and understand what relevant pieces of information I needed to present to my attorney, which were all laid out in this binder. When I spoke to my attorney last hearing, we had a private face-to-face conversation, and he told me that he had not reviewed any of this information.
Stop right now. Okay. So I don't want you to talk about information.
I'm not going to talk about
again, I'm talking. Okay. So one person can talk at a time, and I'll give you an opportunity to speak, I promise. But for now, I'm talking. Okay.
I understand.
You just interrupted me again. Don't do it again. Right? So I don't want you to speak about private conversations you had with your attorney about what evidence that you might have given him or didn't give him. Procedurally, we need to determine whether or not this is the appropriate venue. I know the notice of hearing says that that's what we're here for, but before we get to the substance of your motion, sir, I need to determine whether or not it's procedurally proper because of what I laid out. There has already been a finding that you lack fitness to proceed. And right now, there has been no contrary evidence presented to the court from a Tier 1A mental health professional, which is a psychologist or a psychiatrist, saying otherwise. So the only evidence...
This guy and American courts debating would be pretty awesome to see. Yes.
Evidence in the record concerning your fitness right now is a report from a psychologist who's licensed in the state of North Dakota, a Tier 1A mental health professional, determining that you lack fitness to proceed. And so once that happens, all things stop until there is a finding that you are now fit. I understand that you don't agree with the finding in the first place.
It's offensive.
Again, I'm talking and you're interrupting. So I understand that you don't agree with the finding, and that's fine. But until there's a contrary finding, the court can't move forward. Do you understand that, sir?
I don't understand it, to be honest.
Okay. I'll hear from Ms. Duffy about the procedural posture of the case and whether or not I can consider the motions. And then if so, we'll talk about the substance, and then I'll hear from Mr. Barkas, and then I'll hear from Mr. Hildebrand.
No, this is not the Miss Duffy you're used to. This is North Dakota.
Starting kind of at the back portion, I think at this point, there's kind of a deadlock. I don't intend on signing a stipulation that he is currently fit. I believe Mr. Hildebrand does need some treatment at the state hospital related to the motion that he filed last week. I believe that's a motion for the court to allow him to represent himself. Mr. Barkas has not filed to withdraw. I'll let the court decide that on their own. I obviously don't take positions on that. That's between Mr. Hildebrand, Mr. Barkas, and the court. But procedurally, I think that where he's at right now, restoration is appropriate until there's a finding otherwise. There was at that hearing the last hearing, the court agreed, the court took into account the state hospital's letter. They did hear from Mr. Hildebrand related to the letter that he submitted to the court. That's also filed in there. The court had taken judicial notice of that as well. After that hearing, the parties had agreed to suspend the proceedings. Mr. Hildebrand had agreed to go as well. So that's kind of where we're at right now. I don't think there's any other issues that I didn't mention.
All right. Mr. Barkas, what's your position concerning the procedural posture of this case?
Thank you, Your Honor. In addition to filing the motion for evaluation, the state hospital also has made a determination on criminal responsibility evaluation. And I think that was in part of the reason to send Mr. Hildebrand to the state hospital is to determine whether or not he was criminally responsible at the time. I hear what Mr. Hildebrand's saying. I think there has been a significant breakdown in the attorney-client relationship, and I think it revolves around this motion.
Well, none of those words made him any closer with his client. Don't worry, guys. His client is about to talk. Yeah.
Stuck between a rock and a hard place. I'm not a medical professional, so I can't say that a psychologist at the state hospital is wrong when they write that in a report. And so procedurally, I think the court really doesn't have an option. I have no problem with drawing from this case, and I'm prepared to do so. The issue that I have is this court also finds him not fit to proceed. So can someone in Mr. Hildebrand's condition knowingly withdraw from a case? And that's been my concern, and that's been my one holdup from filing the withdrawal. But even if he's back to fitness, I don't think I'll be able to repair the attorney-client relationship.
Yeah, but you can't withdraw. You cannot. Not right now.
All right. Mr. Hildebrand, I'll hear from you. Not about the substance of your motion, but rather about the procedural posture of the case.
Well, guess what, Judge?
Go ahead.
When you say the procedural posture, what exactly do you mean by that?
I mean, do I have the ability to make the decision and provide you the relief that you want in light of the fact that the statute says all proceedings are suspended, the court order finds all proceedings suspended, everything is placed on pause except for legal objections that can be determined without your participation?
So I don't have the ability to contest these charges, right? Or these findings right now? Because that's what I had prepared for.
Well, I understand that's what you prepared for. I'm saying I don't think the statute allows me to do that.
Well, I mean, to be 100% honest with the court, I have borderline personality disorder. This is a disorder that is characterized by emotional instability and impulsivity. When I present myself in court, these symptoms aren't going to appear because they usually tend to occur when there's an experienced abandonment or even a perceived abandonment of some sorts. So when my fitness evaluation was scheduled in Jamestown, I was required to be there at 9 o'clock in the morning, which was a reasonable time, but I cannot drive. I couldn't drive myself because my license is under suspension. So I was relying on an external source to get me to Jamestown. When that external source would not respond to my messages, and I had felt that perceived abandonment that I felt, with the context of my mental health diagnosis, that specifically affected my demeanor and the way that I behaved and the way that I carried myself into that meeting. And so when he met with me, that interviewer met with me, he saw a very tiny little sliver of, my disorder, but this does not represent my baseline functionality whatsoever. My baseline functionality would be how you see me today. I can control my behavior. I'm not under any sort of mental duress. There's nothing going on right now. But the very specific circumstances in which that evaluation took place were the very specific circumstances in which they shouldn't have taken place. And this honestly is based around, like I said before, specific emails that were given to my attorney, and he made his referrals based on those emails. Actually, I won't talk about what was in those emails, but I want to say that there was nothing in there that gave him any indication that I was mentally unfit to proceed. What it did contain, however, was valuable case material, relevant defense arguments. All of this stuff I had spent the past 2 months compiling, and somebody that's unfit to proceed would not be able to provide all of this information. This is a thick binder worth of stuff. It has my mental health diagnosis that I got from Prairie St. John's in Fargo because I had my mental records released. It has, relevant, even exculpatory evidence. There's a bunch of things in this binder, and he had told me in our last face-to-face, he had not even had the chance to review it, yet it had been in his possession for 2 months. I gave him even links to videos where he had the prerequisite understanding of my mental health disorder in order for him to navigate the nuances of this case appropriately. He didn't review any of that information. And so when he made his referral, when that referral was made, he had not taken any of the context or any of the information that I had given him into consideration when he made that. It was it was arbitrary, it was not necessary, and it has questioned my competency, and that has been harmful to my defense. It has been harmful for there's been reasonable delays in my speedy trial that I should be entitled to. There's a bunch of constitutional failures by my attorney here, and I feel like the court needs to address those as well, because I'm being scrutinized unfairly for a mental health condition that does not affect my cognitive capacity. It strictly affects my impulsivity and my emotional responses under significant stress. And that is not likely to happen in this courtroom because this courtroom is a controlled environment where I cannot face some sort of perceived abandonment. There's
Right, not stressful at all. Nope.
no way I can feel that here. It's usually resulting in interpersonal relationships where I feel some sort of abandonment in those. This is not the setting for me to have, to necessitate a referral to go and meet with a competency evaluator. My criminal responsibility findings are relevant because I significantly believe that my mental health disorder affected my ability to, process what I was doing at the time of the actions that are, bringing about this case, but not in my ability to prevent a defense, not in my ability to handle court procedure. None of that stuff is relevant to my.
So, long story short, Judge, I have mental issues that make it okay for me to break the law, but not okay for you to find me incompetent. That's rude.
BPD. And I feel like it's very important for this court to understand that there's stigma. There is stigma surrounding my mental health condition that needs to be, it needs to be explained in the right, proper way. And I feel like an expert testimony will be able to do that and will elucidate on it much better than I can. But as far as my case preparations go, and as far as understanding the legal counsel, my lawyer, I understand the processes. I know what the preliminary hearings for. I know all of this.
Mr. Hildebrandt, again, I asked you to talk about the procedural posture of the
Then I have
case.
nothing else to say.
All right. So here's the legal framework that the court is required to consider. Generally, a person has a constitutional right to counsel under the Sixth Amendment and under the equivalent provisions of the North Dakota State Constitution. As a corollary right, a defendant has a constitutional right to represent themselves. To represent oneself, the person necessarily waives the right to counsel. Those rights are mutually exclusive. There is no right to stand by counsel. However, in Godinez versus Moran and recognized in North Dakota's court system under State v. Dahl, 2009 Indy 2009 Indy 204. Quote, a defendant must be competent to waive the right to counsel and the waiver must be knowing, voluntary, and intelligent. So that's a direct quote from State v. Dahl, 2009 Indy 204, paragraph 22, citing Godinez versus Moran, 509-389 or 509 U.S. 389. It's a 1993 case. There are a number of cases dealing with the right to counsel. The preeminent case, there's 3 cases that the court has to be concerned about in light of the defendant's request. The first is Ferretta versus California, which was decided in 1975. In Ferretta, the court made clear that there can be a knowing, involuntary, and intelligent waiver of the right to counsel and the right to self-representation, considering certain factors that the court is required to consider. Thereafter, Moran was decided in 1993. And again, the defendant, that one deals with whether or not a person can waive their right to counsel when there might be some mental health concerns. In that case, the Supreme Court made clear that that waiver of the right to counsel must be knowing, voluntary, and intelligent. Because it needs to be waived in a knowing, voluntarily, and intelligent way, the person can only be granted the waiver if they are competent. At that point, trial competency was at issue, not decisional competency. So in Godinez versus Moran, the issue was adjudicative fitness to proceed. The U.S. Supreme Court determined that a person must have the adjudicative capacity to make that informed decision about whether or not to waive the right to counsel with respect to trial. There is another case that was decided in 2008, Indiana v. Edwards.
Yep, that's what I have right here.
So again, I'm talking and you're not.
Am I allowed to talk at all?
You'll be given an opportunity. This isn't a discussion. This is where I'm issuing my order. And so again, when I'm talking, you're not talking. Okay? So in Indiana versus Edwards, the court held that in certain circumstances, an individual may be well able to satisfy Dusky's mental competence standard, where he'll be able to work with counsel at trial, yet at the same time, unable to carry out the basic tasks needed to present his own defense without the help of counsel. And so researchers and court commentators like Mr. Slobodjan or Professor Slobodjan read Edwards.
Court commentator. Is that a job? Is that like a real thing to get paid for?
To say that a person who has a mental illness, they normally should not be allowed to conduct their own defense, even when competent to make a waiver decision, in large part because doing so might harm their case. And so there are commentators reading Edwards in such a way that it is an exception to Ferretta. Ferretta meaning the opportunity for you to waive your right to counsel and represent yourself at trial. Moran sort of limited that and said, well, a person needs to be fit before they can make the decision.
Well, that last one was pretty scary to me. Anybody who has a mental health disorder should not be allowed to represent themselves at all, even if they are competent? No. Wait, hello? All mental health disorders are not equal.
And Edwards determining that even if the person is fit to go to trial, that might not mean that the court should allow counsel to withdraw when doing so will prejudice their case. In this case, procedurally, I don't believe I have any option because I don't think that the proceedings are not suspended. This is not the appropriate procedural time to contest the findings of competency. Furthermore, in a recent North Dakota Supreme Court case, State v. Rowland, it was one that I was involved in. I wasn't the trial judge that made the decision, but I was the trial judge on remand. In Roland, the North Dakota Supreme Court reiterated the fact that the state bears the burden to prove a person fit to proceed, not the defendant. And so,
Wouldn't the defendant have to
So
prove
again-
themselves to be unfit to proceed as well?
no. So that.
It says in, it
So
says in
again,
Edwards,
sir,
it said it in the end of the Edwards.
when you're
Court
interrupting me and talking,
You're not giving me a chance to
so
speak.
sir, this is
This
demonstrating
is a
to me.
violation of my Sixth Amendment rights.
Sir, this is demonstrating to me on the record.
It's not
reasons-
demonstrating anything
Again,
other
you
than you're
can't
not
listen
letting
to
me
my
speak.
directives. My
You're not
directives
letting
are
me stand up for
not,
myself.
you will have an opportunity, but here you're
No, you're not
interrupting
giving me
me.
that
And again, you're
opportunity. I
doing
have
it
nothing more
again.
to say.
So the court at this point is going to hold the defendant's motion in abeyance until there's a finding of fitness. Ultimately, that's the court's conclusion. The court also notes that the report from the Tier 1A mental health professional found two independent reasons the defendant was lacking fitness. The first was the borderline personality disorder of which he speaks. The second was that his speech was pressured and he appeared to have reaction and spoke in very pressured manners and such that the evaluator believed that the defendant was experiencing acute psychosis relating to amphetamine use. Whether that's true or not, ultimately the findings were
What?
that in light of the pressured speech, the inability to redirect the defendant, the inability for the defendant to respond appropriately to one's questions, indicated to the evaluator that he believed you were experiencing psychosis from amphetamine use. Your presentation in court appears to confirm that behavior. And so I'm putting that on the record now. That's demonstrating to me not that you're fit to proceed, but in fact the opposite. So at this point, it is a fundamental due process concern. It is a prerequisite to prosecution. The court cannot move forward until there is a finding of fitness. The state under Roland bears the burden to prove fitness. There will be an opportunity at some point when a Tier 1A mental health professional determines you are fit for you to challenge the findings if you want. But the first step is a Tier 1A mental health professional needs to provide that opinion because your attorney is not an expert in that. Ms. Duffy is not an expert in that. You are not an expert in that. So first step is we got to have a psychologist say you're fit. The only way that's going to happen is if you go and start the treatment. If you're not going to start the treatment.
There's no treatment that can treat this.
Well,
This is not something that can be treated with treatment. If I'm not fit now, then I won't be fit ever.
and
That's
then
the
your-
thing. It's a
and then your
lifelong
case gets
condition.
dismissed. So.
Yeah, after 180 days of unnecessary confinement.
So you are ordered to be treated for up to 180 days. I didn't enter that order, but that's what the order says and that's what the statute says.
Unfair. It's
And
prejudiced.
again, the mental health professional, so again, the licensed psychologist in his report said that if you submitted yourself to treatment, that you would likely be restored to fitness within the 180 days. So that's the medical opinion that's before the court. I understand you might not think it's fair. I understand that you might disagree with the court's findings, but that's where we sit. So I've ruled on the motion. I am going to defer action on it. If at a time that you are determined fit, you want to renew your motion to represent yourself, the court will address your motion then. So I'm not saying that I'll never allow you to represent yourself. I'm not saying that Mr. Barkas can't try to move to withdraw. The court likely would do the same thing with that motion and leave him on as your attorney until which time that you are found fit. And then the court can rule on it. But the case law is such that I can't at this time because the court's findings are that you are unfit, and an unfit defendant cannot fire their attorney and represent themselves. And that's under that Godinez versus Moran case and Indiana versus Edwards. I've explained my reasoning. So Again, the defendant is rolling his eyes and appears to be in open disdain of the court's findings. So I'm putting that on the record as well. The court's made its ruling. Any questions, Ms. Duffy?
There's currently an order for transport to the state hospital. I would ask that he be remanded to the sheriff to begin treatment.
Mr. Marcus? Mr. Hildebrand?
I have stuff that I have to return to my house, and my friend drove me here in my car and she has my keys. So I also need to get my car back to my house and make sure that everything's in line there.
You'll need to make arrangements with the sheriff. There's also outstanding warrants for your arrest. So
Outstanding warrants
yeah, there was a warrant in your case. I don't know for what.
from Fargo Municipal Court.
I don't know for what. I just see the red warrant flag.
And there is no extradition that they will allow. They will not bring me there.
So I understand. I'm just simply stating there is an outstanding warrant, not whether it's extraditable. I'm not making any finding on the warrant, just that the warrant exists. And I am remanding you to custody of the sheriff's department, and they will transport you to the state hospital so you can start your treatment. I wish you the best of luck in your treatment, sir. And again, you're sighing and in open disregard of the court's orders.
That's your interpretation, I guess.
And my interpretation matters as the judge. So you're remanded to the custody of the Barnes County Sheriff, and they'll transport you for the treatment. Good luck to you, sir. That matter is adjourned.
Thank you so much for coming out with me tonight and seeing North Dakota, guys. North Dakota. They have them in North Dakota too. Nowhere is safe. Nowhere. That judge, man, he taught me a lot about the whole competency procedure here today. So that was good. And he got yelled at. So that was good too. And then, of course, there was drugs and a warrant involved, which, thanks for coming out. I will see you next time. Bye.